case on the docket is Thomas Paul Slavin.
Judge Leah Glisson for the state. Defense counsel came from out of town. She is, I believe, speaking with her client in the attorney room.
Flowers?
Miss Sydney Brown. Sydney Brown is the attorney.
Just speaking with him.
May we pass this, Judge?
Sure.
Thank you.
This case is Jatelva Sharp.
Good morning, Your Honor.
Good morning.
Tim Flaherty appearing on behalf of Jatelva Sharp.
Are you Mr. Sharp?
Yes, okay. Mr. Sharp is before the court in case number 2022 CF 1621. This morning, he's going to be entering a plea and entry into the pretrial diversion program.
Okay.
The understanding is that he would plead to the court with a deferred sentence. He'll complete the pretrial intervention. If he successfully completes the PTI, he can withdraw his plea with the understanding that the case will be dismissed. Mr. Sharp understands that if he does not successfully complete the program, he will proceed directly to sentencing. The terms of the pretrial intervention program are as follows. It is a 12-month term, $667 in court cost, $100 cost of prosecution. He'll be required to attend and provide proof of completion of parenting classes, attend and provide proof of completion of anger management course, no violent contact with the victim, initials DC, and no corporal punishment of any minors. Adjudication is withheld. Judge, we've executed a written plea agreement. We've signed the pretrial intervention agreement. We've also signed the referral to pretrial intervention, and those have all been provided to probation, who will be supervising him on the PTI.
All right. Do you all have a copy of that agreement here?
Yes, Your Honor, that's been provided to the probation department.
All right, Mr. Sharp, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Swear you.
All right, Mr. Sharp, first of all, your full name, Mr. Telvis Marquez Sharp, is that right?
Sir.
And, sir, do you understand that based upon what your attorneys represent to the court, you'll be entering a plea of, is it guilty or no contest?
No contest, Your Honor.
No contest this morning to the charge of cruelty toward a child, abuse without great bodily harm. Do you understand that's a charge?
Yes, sir.
And have you had sufficient time to discuss this case and your theories of defense with your attorney?
Sir.
And are you satisfied with the services of your attorney? Has anybody forced, coerced, or threatened you to enter a plea this morning?
Sir.
And this is what, a third-degree felony, I believe, is that right?
Yes, Your Honor.
You understand, sir, that the maximum penalty for this is 5 years state prison, $5,000 fine, or both?
Sir.
Now, you heard your attorney indicate that you'd be referred to the pretrial diversion program. If you successfully complete the terms and conditions of that program, the case is dismissed. But if not, it comes back to the court for sentencing. You don't go back on the trial docket. It comes back for sentencing. You understand that?
Yes, sir.
And you understand that sentence at that time will be in the total discretion of the court?
Yes, sir.
Does the state want to say anything?
No, Your Honor. Christine Boss on behalf of the state, that agreement, and we have provided a score sheet. Caution has no.
All right, the court's going to find, and he's entering a plea of no contest this morning?
Yes, Your Honor.
The court's going to find that the plea of no contest is freely, voluntarily, and intelligibly entered after the defendant's had the benefit of advice of counsel. The court will accept the plea. At this time, I'll withhold the adjudication of guilt. He'll be referred to pretrial diversion program. Do we have a returnable date? Y'all don't do that here. Yeah.
Your Honor, Charles Bear with State Probation. What we usually do is, if he does not do correctly on this, we will turn around and refile it back with the clerk's office.
Okay. But when is he to report to you? Today?
We're going to tell him today.
All right, sir, you need to report to the probation department this morning. The terms of your pretrial diversion program be for 12 months. You'll be required to pay $667 court cost, $100 prosecution fee. You'll be required to attend a parenting class and an anger management class. You're not to have any violent contact in any way whatsoever with the victim in this case, and you're not to have commit any acts of corporal punishment against any minor, sir. Good luck to you.
Your Honor, may I approach with the score sheet?
Yes, sir.
For the record, Your Honor, we did review the score sheet, and it is correct. It's a 36-point offense. Your Honor, I have one more case on your docket.
Yes, sir.
It is State versus Christopher Bilger. Mr. Bilger is an inmate.
They bringing him out?
Bilger, do you have Bilger? All right. Your Honor, I have court in juvenile court. Can I step over there and then come back in a few minutes?
Yes, sir.
Thank you, Your Honor.
All right, next case then is Brandon Gibbons.
Your Honor, I don't see his attorney here.
All right, Robert Cox.
I don't see his attorney here.
Tyson Gurney. Jordan Harris. State versus Jordan Harris.
Your Honor, I don't see that defense attorney yet either.
Mr. Stewart indicated yesterday that he had court in Santa Rosa County and that he would be here just as soon as he's in Santa Rosa County.
All right, what about John Russell Harvard?
That's Mr. Stewart.
Oh, that's who he's with? Okay. Ashley Cornish.
She's pro se, Your Honor. She's an inmate.
How do y'all, you bring the inmates out one at a time? Is that the way they do it?
So I was like, come on.
Are you Ashley Cornish?
I am, yes, sir.
All right, Ms. Cornish, it looks like you have two cases before me this morning. My name is Judge Rasmussen, and it looks like they're both violation of probation.
Thanks.
And ma'am, you have a right to be represented by an attorney in this matter. If you can't afford an attorney, the court will appoint one for you. Right now, you don't have an attorney, is that right?
I wish to self-represent.
You are what?
I wish to self-represent.
Okay, well, you have that right to do that. Do you know at an arraignment whether or not the judge went through the colloquy for pro se?
He did for her original cases. This is her arraignment for the VOP.
Yes, sir.
Ma'am, you understand that you have a right to an attorney.
I do, yes, sir.
You understand if you can't afford an attorney, the court will appoint one for you
Yes, sir.
on each of these cases or both of them.
Yes, sir.
But what you're telling me is you want to represent yourself?
Yes, sir.
Why do you want to do that?
I believe it's in my best interest, and I believe that I am fully capable of representing myself to the best of my interest. So I would like to do that.
You understand that you don't get any special treatment if
I
you
do.
represent yourself?
I do.
Have you ever done that before?
Yes, sir, I have.
How many times have you represented yourself?
Multiple times.
Multiple times?
Yes, sir.
And this is an arraignment?
Yes, sir.
All right, I want to appoint counsel since she wants to represent herself.
Thank you, sir.
When are you going to have a VOP hearing?
Your Honor, if I may address one issue prior to the court giving us the next court date. There has been some concerns raised by probation regarding competency, and the state would request that the court order a mental health evaluation to determine that she is in fact competent to proceed.
All right, do you have any objection to that, ma'am?
Yes, sir, I do. I believe that I'm fully within my facilities to to represent myself. I do not see as there is any legitimate grounds for a competency hearing, and therefore I do object to that.
She does score prison, and the state will be asking for prison this time and did inform her of that last time.
How are you pleading today, guilty or not guilty to the violation of probation?
Not guilty. I would like to discuss a plea agreement with the state.
You'd like to what?
Discuss a plea agreement with the state.
Well, I don't know if they're willing to do that or not. They just indicated that they're looking for state prison time.
I understand that.
But, all right, she's entered a plea of not guilty. Is there anyone from probation here that's talked with her that,
Yes.
Yes, Your Honor. Charles Berry with state probation. I was the officer supervising Ms. Cornish. Upon her release, she was on GPS, and she destroyed the GPS device.
this morning?
She was court-ordered to obtain a mental health evaluation while she was on supervision. We referred her numerous times. She will not go. She has been Baker acted since she's been on the month-long period of supervision when I supervised her. Tried to get her right back into the mental health program, and she just won't go. She won't do anything.
Your Honor, that's not true.
That's
I only
exactly true, Your
had
Honor.
30 days, and during that time, I did not have any transportation, and I was, like he said, quite busy with jumping through the hoops of probation, checking in multiple times a week. So there was no time for me to address that mental health evaluation and get to Fort Walton from the North County.
right.
So,
Since the issue of competency has been raised and the penalty, the potential penalty is severe, I'm going to order that competency evaluation. Who is the doctor that's normally appointed over here?
Your Honor, it just varies. There's Dr. Zeman and there's Dr. McDonald.
They're both in Okaloosa County?
Yes, Your Honor.
Arbitrarily just appoint Dr. Zeman. Need an order. And we'll need a returnable date for her VOP hearing.
It's going to take, usually takes them at least 30 days to do the evaluation, so I would request 30 days out. That would be fine.
Let's set it for a VOP hearing, January 31st. And did you want to set a competency hearing at this time as well?
Yes, Your Honor.
What do you have for date for a competency hearing? Pardon me? Sound like a competency hearing to refuse.
Well,
Let's do that for the competency hearing.
I'm sorry?
What time? 9 a.m., January, did you say 25th or 6th? 26th. 6th? Okay, January 26th for a competency hearing, and then said January 31st for the VOP, also at 9 a.m.?
is there any way that we could possibly get a bond on this violation of probation? I'll have to be retained in custody?
Okay.
Yes, sir.
All right, thank you.
May we set a bond hearing?
You can file a motion for bond.
Yes, sir.
Your Honor, just so the defendant is aware, she's also on probation out of Santa Rosa County. As a result of the addendum to the violation in Okaloosa County, which were new charges and a positive drug test, a violation will be submitted to Santa Rosa County. So once she's finished here, she's going to have to go there and double the score.
Ma'am, you're sure you don't want an attorney to represent you?
Yes, sir.
All right. Okay, any of the attorneys show up on some of the cases we've called? Yes, sir.
Robert Cox, first case.
Who's your client?
Robert Cox. Good to see you, Judge. Welcome to the bench.
Good to see you too, thank you. And your client's name is Robert?
Robert Cox, Judge.
Robert Cox. Okay, is he here?
It's a motion for early termination of probation, Judge. he served 50%, and I think he's completed all the terms, no problems whatsoever. I'd like to get him off. I don't think the probation has any objection.
What was his original term of probation?
It was 2 years, Judge. He
2
served
years?
2 years. He served over a year.
What's the state's position on it?
He was originally charged with lewd, lascivious molestation and sexual battery. He pled to felony battery in September of 2021. The only probation terms given were 2 years of probation, no contact with any minors, and no contact with the victim. Main intent of that plea was to ensure there was absolutely no contact with the victim and none with minors, besides court costs. He's not scheduled to terminate until September of 2023. We reached out to the victim in accordance with Marcy's law. She is very much opposed to him being able to early terminate. We believe it's essential for the no contact with minors and no contact with the victim to remain in place for the full 2 years as contemplated. So we would respectfully request Mr. Cox remain on probation for the full period.
At the time, I wasn't the sentencing judge, but at the time he entered a plea, what was the understanding, if any, about early termination?
I don't believe there's anything contemplated in the agreement as far as early termination.
Judge, the probation officer agrees for him to be off early termination, and I think they've recommended it. He's been a model citizen on probation. And we're going to get into it. I want to tell the court a little bit about what the evidence was in this case. If that's okay. I've got an affidavit of the victim's grandmother that says, and I've got copies for the court too that I can give you, that says, my name is Jovita Garza. I live in Texas. I'm a maternal grandmother of Chloe Cox. I personally know that Chloe Cox was not being truthful, what she said about Robert Cox. Then she says, my granddaughter, Levita Cox, sowed the same type of allegations about men in Texas, which were not true. I personally know that Chloe Cox does not get her way on anything. She is very vindictive and will do what she can to get even. She is untruthful about anything she says. I heard Chloe Cox tell my granddaughter when she was out here visiting us in Texas that she had to make this up about Robert Cox in order to get here, and that Mr. Cox was very strict and not allow her to do a lot of things. I know that this did not happen to Mr. Robert Cox, and that Chloe Cox was not telling the truth. I heard her say that. That's an affidavit, sworn affidavit, and that's why we got the federal felony battery. Another one, Madeline Piper. I'm Madeline Piper. I was born April 22nd, 2005. I'm the daughter of Misty Royce. I reside with my mother. I resided there when Chloe Cox came to live with us in February and March of 21. Approximately 3 or 4 days before Chloe Cox was told to leave because of drugs. Chloe Cox came in the room when she was drinking on drugs and stated she had lied on her grandfather, Mr. Cox, about Mr. Cox molesting her because she was mad. That's another affidavit, sworn affidavit. I've got numerous of these. This is the victim. I've written 4 letters requesting these charges be dropped. I will not testify in this case. I previously told you that I would not recall the facts of this case anymore, and I cannot remember them. I was extremely upset at the time. It's causing me a great deal of stress that you will not honor my request to have the charges dropped. She wants them dropped because she didn't want to take the stand. The last affidavit, Misty Royce. Chloe Cox resided with me in my home from February 21 to the end of March 21. She told me several different versions, all different from each other, of what happened to Mr. Cox. Chloe Cox told me that Dolores Cox had molested. That's poor old Miss Dolores Cox's wife had molested her. Chloe Cox, then on one occasion when she was crying, told me that nothing happened to Mr. Cox, that she was sorry, that she got all this started as all she wanted to do was go to Texas, and that was the only way she could make that happen. This was heard by my daughter also. Chloe Cox got my nephew, who is a co-defendant in her case, on home invasion, hooked on drugs. She's also threatened me with a text when she found I was going to be a witness for the for the defendant. These are affidavits. I'll give you court a copy of them And they've been filed in the
Of the underlying case.
Thank you.
Barry.
Your Honor, Charles Berry, representing the State Probation Office. I don't supervise Mr. Cox. I talked to his officer, Mr. Harris. We cannot recommend a early termination on someone that's on for a sex offense.
It's not-
Down from a sex offense. We cannot. We can say we don't object to it, but we're not recommending it. He does still owe $201 in court costs.
We can pay that today, Judge.
All right. Seems to me that, though I looked at those affidavits quickly, they're a year older. They're back in 2021.
During the case, Judge, during the underlying case.
I understand. He had an opportunity to go to trial and require the state to prove his guilt. He chose not to do that. He accepted a 2-year probation, and I'm going to deny the request for early termination.
Okay. Thank you. That's all we can do. Thank you, Judge. I've got another
Sir, you'll
case.
remain on probation under the same terms and conditions originally imposed. You had another case, Mr. Hill?
Yes, sir, Judge. I got one more. Rice and Gurridge, Judge.
Rice and Gurney?
Right. This was heard before, and court almost granted it, but it didn't. We're asking the monitor be removed from him, and he's got an ankle monitor, and the judge gave us to come back for reconsideration. I wasn't here at the time. I was out of state, and might not have made any difference, but I'd like to re-argue the case because a lot of points wasn't brought up at the other hearing. He's got an ankle monitor.
Okay, and what are you asking for?
I wanted the ankle monitor removed. And
So you want modification of was that a term of pretrial release or as part of his a sentence if he entered a plea?
no, it's not. It's pretrial release is recommended that they didn't know why it was on anyway.
Okay.
And that's all we want is the monitor be released. Let me tell you briefly.
Tell me, is it the motion was already heard by another judge and the judge denied the motion?
Correct, but he gave us, it was last Thursday, I believe, and it came back today for reconsideration. There's a lot of things that wasn't brought up to the court at that time. And I'd like to hit the high points of it. He didn't grant it with prejudice. He granted it. He said, you can come back for reconsideration when I get back. And that's what, he was 18 years old when he was arrested. He was 17 years old when this started. And more than a year after they received these reports from his telephone, he's never been in trouble in his life. He's a straight A student. He had a scholarship at Florida State, band scholarship. He was an honor student at Crestview High School. Pretrial Services recommends it. This all happened with this app called Discord, and he receives these private messages from Discord. He doesn't know what's on them until he opens them, and there's adult porn and there's child porn. And then a year later, they arrest him. He didn't look at them, but just a few minutes. He did send a few out to his friends because he's 17 years old. But you look at the times, they're seconds and minutes. There's no prejudice to the state for removing this monitor. There's no victim in the case. This is the same, Discord's the same app that just Florida State quarterback, second string, got arrested on. You don't know what's on it till you open the email on it. I've never looked at it, but that's what they all tell me.
Well, let me ask you this, or let me ask State, what's the purpose of an ankle monitor in a case where it's a possession of pornography?
Judge, in The GPS acts as a deterrent for the defendant and a safeguard for the community, as pretrial services is able to check those coordinates and monitor as activity. In addition, it's a standard condition for the sex offenses in Okaloosa County on pretrial conditions. Judge Selector at first appearances ordered the sex offender conditions that apply, or that he believed apply in this case. In this case, no unsupervised contact with minors and GPS before release. In addition, if he was going to be placed on sex offender probation, for Jessica Lunsford Act purposes, probation determines the age of the child victims in the videos as 15 or under, and that would require him to be on a monitor anyway, anytime he is on supervision.
We're talking about pretrial right now.
Yes,
We're not talking about a part of a sentence. We're talking about pretrial.
that's correct.
Judge, he has a job at Bamboo Restaurant. The GPS monitor keeps continuously going off. I mean, this is a good kid. He never had a problem in his life. He got on his stupid Discord app, and that's what happened from there. And then, you know, he's not denying it. He shouldn't have looked at it, but he did not know what was on it until he opened the app. We'd ask you to remove the monitor. He's been a perfect model since he's been on here. Pretrial recommends it.
Your Honor, if I may. Defendant in this case has been charged with 10 counts of possession of child pornography. Children in these videos were as young as infants being penetrated. There were 22 that were located on his cell phone as to whether or not he knew what was on them when he was viewing them. Either way, a year later, when they searched his home, he directed law enforcement officers to a hidden folder on his cell phone that had the child pornography in it. So he certainly knew at that point what he had on his phone. We have already had no objection to GPS being $1 per day.
I get that, but what you're alleging was on his cell phone. Were these photos of him with minor children?
No.
No, Your Honor. These were photos and videos of other children being penetrated and sexually abused.
And again, what would be the purpose of the monitor? That's what I'm...
It provides a safeguard to the community because pretrial services can monitor his coordinates and check in as far as where he is.
Well, I get that, but I mean, there's no allegation that he himself has committed any obscene act with a minor child?
No. No.
Just possess the child pornography.
I'm going to grant your motion. I don't see the need for a monitor under the circumstances. So the motion be granted.
Thank you, Judge. We'll prepare an order on that, Judge.
All right.
Good to see you, Judge. Thanks a lot.
See you too. Where did we leave off? 1 and 2 are ready? All right, let's call number 1, Thomas Paul Slavin.
Thea Glisson for the state, Your Honor. The defendant's an inmate.
Mr. Slavin looks like he's got, 3 Okaloosa cases?
He does, Your Honor.
And then I've got some correspondence from Jackson County on a sentence that the judge over there took a plea, but transferred it over here for sentencing. And here's my quandary with that. I don't think I have the authority to sentence him on a case outside of this circuit.
Right. I've spoke with defense counsel about that. I think we're in agreement that the best thing to do is he's going to get credit time served for all of these cases today and be done, so then he could be transported back to the county where he has pending cases and be sentenced there.
That's correct, Judge.
What is your name, ma'am?
Your Honor, Sidney Brown for Mr. Thomas Slavin in cases number 20 CF 2442, 2956, and 2957.
And, Your Honor, the state and defense have reached an agreement. The defendant is going to sign the plea agreement, and then we will present that in the score sheet to the court. May I put the plea terms on the record while she's signing? Okay. Your Honor, in 20 CF 2956, the state and the defendant have reached an agreement to withdraw his previously plea previously entered plea of not guilty and enter a plea of no contest to counts 1 and 2. He will be adjudicated guilty as to both counts, receive credit time served for both counts, $415 court costs, and $100 cost of prosecution. In 20 CF 2442, he will withdraw his previously entered plea of not guilty and enter a plea of no contest to counts 1 through 3 as charged. He will receive adjudication of guilt as to each count, credit time served for each count, $515 court costs, and $100 cost of prosecution. And finally, in 20 CF 2957, the defendant withdraws his previously entered plea of not guilty, enters a plea of no contest to counts 1 through 9 as charged. He will receive an adjudication of guilt, credit for all time served for each count, and $515 in court costs, and $100 cost of prosecution. And I do have a score sheet for your honor and the plea form if it's signed.
May I approach, Your Honor?
All right, Mrs. Slavin, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And what's your full name?
Thomas Paul Slavin.
All right, Mr. Slavin, I have a written plea agreement your attorney's just handed me. It's signed by the defense attorney, also by the prosecutor. And it purports to have your signature as well. Is that your signature, sir?
Yes, Your Honor.
And prior to signing this, did you read it?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you go over it with your attorney?
Yes, Your Honor.
Did you satisfactorily explain the terms and conditions of the written plea to you?
Yes, Your Honor.
Do you have any questions concerning it this morning?
No, Your Honor.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense are charged with your attorney?
Yes, Your Honor.
And are you satisfied with her services?
Yes, Your Honor.
Has anybody forced, coerced, or threatened you to enter your plea this morning?
No, Your Honor.
Have you had any drugs or alcohol within the last 24 hours?
No, Your Honor.
So what you're telling me is you're entering this plea freely and voluntarily of your own will, is that right?
Yes, Your Honor.
All right, and how's he pleading to all cases, all counts?
I'm sorry, Your Honor?
How is he pleading to all cases, all counts?
Yes, Your Honor. As charged.
How is he pleading?
Oh, he's pleading no contest, Your
All
Honor.
right, the court's going to find that the plea of no contest is freely, voluntarily, intelligently entered after the defendant's had the benefit of advice of counsel. The court will accept the plea. In case number 2020-2442, he'll be adjudicated guilty on both counts, possession of controlled substance and possession of paraphernalia. The court will adjudicate him guilty, and he'll be sentenced to, let's see, that, I thought you told me there were 3 counts on
Which one, Judge?
2442.
Just 2, Judge. Possession of a controlled substance and paraphernalia.
Okay.
That was an amended information that took it from 3 to 2.
All right, he'll be adjudicated guilty on both counts. It's going to be judgment sentence to the court that he'll be sentenced to time served, and he'll get credit for time served. He'll be required to pay $515 court cost and $100 prosecution fee. In case number 2956, on counts 1 and 2, credit card forgery and possession of a counterfeit stolen credit card, he'll be adjudicated guilty, and he'll be sentenced, also he'll get credit for time served, sentenced to time served. He'll be required to pay $415 court cost and a $100 prosecution fee. On 2020-2957, on all 9 counts, he'll be adjudicated guilty, and he'll be get credit for time served, sentenced to time served. He'll be required to pay $515 in court costs and a $100 prosecution fee to be on each case. Sir, you have a right to appeal the legality of sentence to the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. You will need to be fingerprinted on these charges, sir.
May I be heard, Your Honor? Your Honor, Mr. Slavin is from the Bay County area. We understand that the court has no jurisdiction to order DOC where to place him, but we'd appreciate a recommendation that he be placed in Bay County, if at all possible, Judge.
Well, my sentence is not a state prison sentence.
Correct.
Oh, you're so right.
Correct, I'm sorry.
I apologize, Your Honor.
That's all right.
That's
I'm
right.
not
We'll handle that in Jackson County.
And what I'm going to order is that he'll be transported back to Jackson County.
Thank you, Your Honor.
I guess that's what, the 14th Judicial Circuit over there?
Correct, yes.
Yeah, he'll be sentenced, he'll be transported back there for imposition of the sentence before, I think it was Judge Garcia. if
That's
I'm not
correct, Your
mistaken,
Honor.
And she'll have to impose that sentence.
Thank you, Your Honor.
And Madam Clerk, it is the state's intent in exchange for this plea to not take any action on any FTAs that he may have on these cases. I know if I don't put it on the record, I'll get a follow-up email about that before the end of the day.
That's all I have, Your Honor. May I be excused? Thank you, Judge.
All right, who's next? Number three. Okay, Brandon Givens.
Judge, good morning.
Good to see you.
Good to see you. I'm James Owens, and I represent Brandon Givens. Can the state now approach the bench?
Yes, sir.
A word with my client.
Yes, sir.
Judge, yes, the defense has requested it be passed.
State has no objections, my understanding.
That's correct, Your Honor.
All right, let's go ahead and pass it to the next VLP date before whoever will be sitting here.
I'm sorry? That's not a good date for me. Excuse me? Yes.
9 a.m.? All All right, we'll pass it till January the 5th at 9 a.m. What about Mr. Sharp? You got him?
That's what I'm trying to get. She won't do it today.
Okay. Oh, yeah, he's on 2 pages. Kenneth Fuquay,
Your Honor, that's Mr. Stewart's case. I don't believe he's here
he's
yet.
still not here?
He also has Mr. Harvard and Mr. Harris.
All right, what about Jordan Harris? Ready for that?
He has Mr. Stewart has Mr.
He's got
Harris
that
as
one,
well.
too?
Yes, sir.
John Harvard?
He has Mr. Harvard.
Okay. How about Ashley Cornish?
We did that one, Your Honor.
Oh, she was the pro se?
Yes, sir. The next one I have is Brian Denman.
Yep. Brian Denman, Brian Delmar Denman.
I'm done with Brian.
He's got 3 VLPs, is that right?
Yes, sir.
Mr. Denman, are you represented by an attorney?
No, sir.
So you understand you have a right to be represented by an attorney? If you can't afford one, the court will appoint one for you? Did you want to be represented by an attorney? What's the state's position on it?
I'm sorry, did you say you wanted an attorney?
Well, I thought he said he didn't. You want an attorney?
Yes, sir.
Let's see, I think if this is the one I'm thinking about, this is the one where the department is recommending just to let his probation terminate?
Your Honor, if you don't mind, Charles Berry was state probation. I think it was a case of who's been on probation for an extended period of time, and he hasn't got the restitution money paid. And I'm kind of trying to take this off memory. I don't have anything in front of me. He was on, I think he served a prison sentence. He had community control. He did the community control with me. It rolled over to probation, and now it's coming up on a termination date.
It also says allegation number 5, failure to complete batterer's intervention.
Your Honor, we sent him to a referral to Pattison Professional Counseling. Tommy, one of the counselors down there, did a anger management assessment on him and a substance abuse assessment on him, and he completed that treatment with the understanding that he did not need batterer's intervention, was the way it was referred, or that Mr. Rowland advised me.
I'm just referring
Right.
to the
Right.
affidavit.
Let me make sure I'm looking at the right. I'm looking at the probation recommendations. This is the one I was thinking about. And apparently his probation terminates today. Without further, if nothing's done, it terminates today. And that was the recommendation of the probation officer, with the understanding that the remaining monetary obligations be reduced to judgment. Now, is the state opposed to that, or?
No, Your Honor.
I mean, I can appoint him an attorney and go through that, but if there's no objection to that, I'm inclined to go ahead and do that based upon what I'm reading. What it says is, it says, due to the nature of the original offense, the defendant was a violent felony offender of special concern. The officer respectfully requests a warrant for his arrest. That was done. The defendant has completed the majority of his probation since starting back in December 19, 2017. He has obtained one new law violation for battery and a technical violation for a drug test. Previous to this violation, his probation was modified to community control due to the violations. He has since been cooperative and has not obtained any new violations. Therefore, the officer requests the defendant be allowed to terminate from probation on December 8th, and that the remaining monetary obligations be reduced to judgment. That's the recommendation, and if there's no objection, I'm going to follow that recommendation based upon all the circumstances.
No objection, Your Honor.
All right. Sir, I'm going to, first of all, any outstanding monetary obligations that he has, they'll be reduced to a judgment lien, and for which let execution issue, they'll accrue interest at the legal rate, and your probation will terminate automatically today, sir. I'm not going to take any further action on the violation of probation, but you make it to midnight today, and you're off probation. You understand that?
Sir.
Good luck to you, sir. And that's on all cases. Next up is Kelly Hutto.
Mr. Hutto is incarcerated. He's in the back. He'll be out in just a moment.
Okay.
You've got him on the clerk's docket as unrepresented. Actually, if you'll look at lines 75 and 78 on the clerk's docket, or in the clerk's printout for this case, you'll see that we were appointed, and I did a notice of appearance some time ago.
So you're representing Mr. Hutto?
That's correct, Judge. Judge, we've been in negotiations with the state to resolve this. We discovered an error on the sentencing guideline score sheet. It should have been 6 points and not 12. And then we have a written plea agreement. I already have. I spoke with him about it back in lockup, but Judge, there's no pass-through for me to pass paper. I have to read it to him. Prosecutor, if you'll do the honors. Here's the first page of it. Your Honor, if I can approach. The agreement, Judge. And with the correction on the score sheet. The agreement here, Judge, is for 180 days county jail, adjudication of guilt. I've explained to him that that will make him a convicted felon and what that means. And he's to get credit for, I calculated at 156 days time served. That's based on an arrest date of April 20th, bond date of May 2nd, both of those in 22. And no, that can't be right. No, I think one of them's in 21, Judge, and I just wrote it down wrong when I was transcribing it over.
All right. Any objection to the credit for time served?
No, Your Honor.
Calculated? All right, sir, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You're Kelly Hutto?
Yes, sir.
All right, Mr. Hutto, your attorney's handed me a written plea agreement. It's dated, well, it's not, and it's not signed either. So he'll need to sign it.
But I gave you the other copy. You may have more than one copy.
I've got the score sheet, and I've got the agreement.
It's only a two-page agreement, so yeah, you've got my extra copy.
Oh, I'm sorry.
Actually, I think, yeah, that's...
All right, there it is. All right, Mr. Hutto, I do have a written plea agreement from you. dated today, is that your signature?
Yes, sir.
And prior to sign this, did you read it?
Yes, sir.
And did you understand it?
Yes, sir.
Did you go over with your attorney?
Yes, sir.
Did he satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning?
No, sir.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense to charge with your attorney?
Yes, sir.
Has anybody forced, coerced, or threatened you to enter this plea?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
All right, the court's going to accept the plea to the one count of violation of community control. He'll be adjudicated guilty. If he hadn't already been adjudicated guilty of the underlying offense, he'll be adjudicated on that as well. I'm going to sentence him to 180 days in the county jail. He'll get credit for time served, which is 156 days. So you have a right to appeal the legality of the sentence of the court. If you can't afford an attorney, want to be appointed, you have 30 days from today to file your notice of appeal. You will need to be fingerprinted on these charges.
Your Honor.
Thank you, Judge.
That was a revocation.
Yes, yeah, probate, community control be revoked. I'm sorry, I didn't say that. Next case is Marina Strangeland.
Judge Leah Glisson for the state. This is 22 CF 1968. This is a fugitive from justice case. It was set for a status hearing today. I'm told she's not in custody and she's not here, but if we could reset this to the next miscellaneous date, so that would give me time to see, because I know she did sign a waiver of extradition, but she was finishing up on some local charges here, so she may have already been extradited.
Okay.
If we may set this maybe for the
December 29th?
Yes, sir. That would be great.
All right, let's set it for December 29th at 9 a.m.
Thank you, Judge.
Tommy Joe Chesser.
Attorney isn't here.
He's not here yet either. All right, Mr. Chesser, your attorney's not here. We'll call.
Oh, I'm sorry.
Okay, apparently she is. All right, are you Tommy Joe Chesser?
Yes, sir.
Yes, Your Honor. Jennifer Flowers, on behalf of Tommy Joe Chesser. Today, we're here in 19 CF 46. We had what basically was a motion hearing last court date, and the judge, Nickerson, that was here, I think he actually ruled on the motion that, and today we were just waiting for a calculation of credit that was going to be given. Kind of a brief backstory. Mr. Chesser had entered a plea to 12-1 DOC back in February 2020. He already had the credit in, over 500 days of credit that was given credit for time served. However, since it said DOC, he had to be transported to DOC, and it took about 3 months. So he was incarcerated an additional 3 months in between his plea date and the date he was released from DOC. It was during COVID, and that seemed to be kind of the explanation. The Judge Nickerson had ruled that he was going to give him that credit towards his probation. He has about 10 months left on probation. So today we were just, I think Mr. Berry was going to calculate the credit.
Your Honor, to the best of our abilities, we calculated how much time he has. And basically, his new termination date now, with that credit that he gained, would be February the 13th of 2023. So I think his original termination date was in June or something, so that, to be fair to Mr. Chesser, that is correct.
All right, let the record reflect then that be the new termination date of his probation. And if you want to, well, we need to get an order to that effect. If you'll do an order, I'll go ahead and
We will get one, I believe, Your Honor.
Okay.
We'll send a modification order indicating that this is the new termination date.
All right, we'll do that.
Thank you.
So ordered.
Thank you, Your Honor.
Thank you, Your Honor.
Lana Shaw Creech. Is that also yours, Ms. Flowers?
Yes, Your Honor. Your Honor, this is Lana Shaw Creech in 21 CF 2735. Jennifer Flowers on her behalf for the record. This was just a status hearing. Ms. Creech is still awaiting placement in Florida State Hospital.
All I can say to the court is that we continue to check on it. She is on the waiting list. It's just she hasn't been transported yet. So we would ask to possibly just set her for another status hearing, possibly on the next, maybe that January 5th date.
January 5th?
Yes, Your Honor.
All right, let's set it for status review on January 5th to see if she's transported to the state hospital. Savannah Matthews, looks like one of yours also.
Yes, Your Honor. Ms. Matthews is present and approaching the podium. We're here today on a VOP in 22 CF 1077. For purposes of today's hearing, we're going to be entering a denial and asking to set for the next miscellaneous date. I just have some information I need to go over with my client.
All right, that would be December 29th, is that right?
Would we be able, because of my own agenda, will we be able to do the January 5th date? No objection.
Any objection?
No, Your Honor.
All right, let's set it for, that'll be a contested VOP hearing then, is that right?
Your Honor, I wouldn't ask for subpoenas. I think this is, I have some information that I'm going to get to the state that I think we can work out a resolution on that date.
So we'll set it for January 5th without subpoena.
Yes, Your Honor. Thank you.
All right, January 5th at 9 a.m. Ma'am, you need to be back in court that date and time. Okay, and you need to stay in touch with your attorney.
Thank you, Your Honor.
Crystal Sherlock,
Your Honor, this is also my case. She's set today for a sentencing. She's not here yet, so my assistant's trying to get in contact. I would ask that we just pass her for right now.
all right, we'll come back to her. Cynthia Slay,
Yes, Your Honor, this is also my case. Ms. Slay is present and approaching the podium now. We're here today on 22 CF 2290. We have a plea and sentencing agreement that's been signed by the parties. May I approach, or would you like me to announce the terms?
or you can hand it to me.
Okay. May I approach, Your Honor?
Thank you. Is there a score sheet attached as well? Yeah, it is. All right, ma'am, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? And what is your name?
Cynthia K. Slay.
Ms. Slay, I have a written plea agreement as stated today, handed to me by your attorney. It has what purports to be your signature. Is that your signature, ma'am?
Yes, sir, it is.
And prior to signing this, did you read it?
Yes, I did.
Did
Yes.
you understand it?
Yes, I do.
Did you go over it with your attorney?
Sir.
Did she satisfactorily explain the terms and conditions of the written plea to you? Do you have any questions concerning it this morning?
No.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney? And are you satisfied with the services of Ms. Flowers, your attorney? Has anybody forced, coerced, or threatened you to sign this written plea?
No.
Have you had any drugs or alcohol within the last 24 hours? So what you're telling me is you're entering this plea freely and voluntarily of your own will. Is that correct? All right, the court's going to find then that the written plea of nolo contendere to both counts, possession of a controlled substance, count 1, possession of paraphernalia, count 2. What was a controlled substance?
Judge, it was methadone.
Methadone?
Yes, sir.
All right. Is freely, voluntarily, intelligently entered after the defendant's had benefit of advice of counsel. The court will accept the plea. She'll be adjudicated guilty at this time, sentenced to time served. She'll get credit for time served. She'll be required to pay $515 court cost, $100 cost of prosecution, and $150 cost. Are you private or appointed?
I'm appointed, Your Honor. I'm with the regional conflict.
And $150 cost of defense. The money is due to be paid within 180 days, failing which it'll be sent to collections. You understand that, ma'am? You have a right to appeal the legality sentence of the court. If you can't afford an attorney, one will be appointed for you. You'll have 30 days from today to file your notice of appeal. And I don't see anything on the plea agreement about notifying Department of Motor Vehicles.
Usually, I don't think we include that, but if it needs to be included on the plea form, we can, Judge.
I'm almost thinking it's required by the statute. Is it drug charge?
What?
It's in the plea agreement. Your Honor, it's in the plea agreement. I think it's number 13, where it mentions that that the clerk's office will submit it and that it'll get done from there.
So you're, right. Done for us.
All right, you have a right to appeal, 30 days to appeal. If you can't afford an attorney, want to be appointed, you will need to be fingerprinted on this.
Okay.
Okay.
Thank you.
Ashley Renee Thompson.
And yes, Your Honor, Jennifer Flowers with the Office of Regional Conflict on behalf of Ashley Renee Thompson. She's going to be withdrawing her previously entered plea of not guilty and enter a plea of no contest to counts 1 and 2 as charged in the information. Those are both misdemeanors. The state is going to be announcing a null pros on counts 3 and 4.
All right, have you got a written plea?
Yes, Your Honor. I'm just going to have her sign it really quickly. We have been over it, but she hasn't actually been able to sign the copy, so. And I'm just going to have the state sign really quickly. I'm sorry, Your Honor. I don't think we need a score sheet.
All right, ma'am, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Your Honor.
And what is your name? You're going to have to speak up.
Ashley Thompson.
Okay, Ms. Thompson, your attorney just handed me a written plea agreement. It's dated today. Has what purports to be your signature. Is that your signature?
Yes, Your Honor.
You put your hand down, ma'am. Prior to signing this, did you read it?
Yes, Your
Did you
Honor.
understand it? Did you go over it with your attorney? Did she satisfactorily explain the terms and conditions of the written plea to you?
Yes, she did.
Do you have any questions concerning it this morning? Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney?
Yes, Your Honor.
And are you satisfied with the services of your attorney? Has anybody forced, coerced, or threatened you to sign this written plea agreement? Have you had any drugs or alcohol within the last 24 hours? So what you tell me is you're entering this plea freely and voluntarily of your own will. Is that correct? All right, the court's going to find, and she's pleading no contest to counts 1 and 2?
Yes, Your Honor.
The court's going to find that the plea of no contest to count 1, carrying a concealed weapon, count 2, resisting an officer without violence, is freely, voluntarily, and intelligently entered after the defendant's had the benefit of advice of counsel. The court will accept the plea. She'll be adjudicated guilty on both counts, sentenced, and on each count she'll be sentenced to 12 months probation, concurrent, one with the other. She'll be required to undergo a substance abuse evaluation and follow through with any treatment as deemed necessary or recommended by the treatment. She'll be required to perform 25 hours community service work at the rate of no less than 5 hours per month. She's not to associate with any known drug users, and she'll be required to forfeit the brass knuckles that were confiscated from her. She'll be required to pay $515 court cost, $100 cost of prosecution, and $150 cost of defense. And what's the state going to do with counts 3 and 4?
State announces a null pros, Your Honor, to both counts.
Let's see. I don't think I've got the score sheet for her.
It's 2 misdemeanor counts, Judge, so no score sheet would be.
Oh, that's right. Okay. All right, ma'am, you'll need to be fingerprinted on these charges, and you have a right to appeal, 30 days to appeal. If you can't afford an attorney, one will be appointed for you. Good luck.
Your mom's here.
And Your Honor, Ms. Flowers is a regional conflict counsel, and the defendant has been ruled indigent. Due to those circumstances, we request the supervision fees be waived.
I'll go ahead and waive the
Thank you.
Thank you, Your Honor.
cost of supervision. Courtney Lynn Baker. Are you Courtney Lynn Baker?
Sir.
Do you have an attorney, ma'am?
Oh, yes, sir.
Oh, here she is.
Casey Etheridge for Ms. Baker, and we've actually filed a motion to withdraw in this case. I don't think the order's been signed. but we were unable to represent Ms. Baker on
Based on a conflict?
to a conflict, yes.
All right, I'll allow the Public Defender's Office to withdraw and appoint conflict counsel to her. So she has 3 cases, is that right? 3
Yes, Your
different
Honor.
VLPs? Is conflict counsel present in the courtroom? Or-
Yes.
Yes, Your Honor.
Ms. Flowers?
Yes, Your Honor.
You just picked up another client.
Okay, yes, ma'am.
And I do have an offer that may resolve today. The state's offer is just an adjudication, credit time served, revoke and terminate probation and court costs. So you would be done with probation if you'd like today to enter a plea. Okay? I'll work that out with Ms. Flowers, if we may have some time and just recall.
Okay, you want to take care of it now, or you just want to meet first?
Does the court require a plea agreement for, okay,
No, if that's what you're
okay.
going to do.
So the state's offer, it's been put on the record, the defendant wishes to accept the state's offer of an admission to the VOP, an adjudication of guilt, revoke and terminate probation, court costs, cost of prosecution, and send all monies to collections. Is probation okay with that, in agreement?
Correct, Your Honor.
Did you want to,
So she doesn't have any questions. She's been previously adjudicated. So I would advise her that that would be the offer to accept.
and Ms. Baker, is that what you wanted to do, ma'am?
Yes, sir.
All right, the court, so what that means is you're admitting the violation of probation. We're going to adjudicate you guilty on the violation of probation and on the underlying offenses, if you have not already been adjudicated on. I'll do that today. Any outstanding cost, any outstanding financial obligations will be reduced to judgment and lien, and the case will be dismissed. Is that what you want to do?
Yes, sir.
All right, so ordered. That's on all 3 cases.
Yes, Your Honor. May I approach with a score sheet, Judge? Or do you require a score sheet for?
Yeah, you have one, Honor?
Yes, sir.
Sierra Banks. Sierra Banks. She's incarcerated. Okay.
And Your Honor, Casey Etheridge for Sierra Banks, and Your Honor, we also filed a motion to withdraw in this case based on a conflict, and so we cannot represent Ms. Banks on this. I don't believe the order's been signed yet.
All right, Ms. Banks, your attorney is moving to withdraw from representing you based upon a conflict of that she's determined she has, and you have a right to be represented by conflict-free counsel. Do you want to be represented by an attorney, ma'am?
Yes, sir.
All right, I'm going to allow the Public Defender's Office to withdraw, appoint conflict counsel to represent her.
And Your Honor, in addition, she has a new law violation on the south end of the county, so the state has filed motions on her VOPs to transfer those to Division 1, I believe. Yes.
Sierra Banks, what's this out there?
Ms. Flowers, I'm going to appoint you to represent.
Yes, Your Honor. You won't have me. You'll have or Katie or Rudy.
Rudy on the...
Okay, so you'll have Rudy on all of them. Okay. So I'm sorry, I missed the first part. Do we need, are we here on violations of probation?
Yes, and there's also a new law in Division 1 that we're going to transfer these cases to. There's a motion.
Okay. Well, for purposes of today, we would enter a denial.
Okay. All right, then that'll be set on a docket down in the south end of the county.
Yes, Your Honor. I'm
we
not
have
sure
a-
if those,
Do we have a date for that?
if we could just put it on the pretrial docket as soon as those motions are, and orders are filed, I believe it'll fall off this docket and go right on to the Division 1 docket.
Pre-trials for this division look like they're December 28th for inmates. All right, we'll put it on for December 28th at 9 a.m.
All right, thank you.
Christopher Bilger.
Morning, Your Honor. Tim Flaherty appearing again on behalf of Mr. Bilger. Judge, the docket may reflect that this was a public defender case. We filed a motion to relieve the public defender on December 2nd.
I don't know whether that order's been entered or not, but you're going to represent Mr. Bilger?
Yes, Your Honor.
Public Defender's Office, where's Miss Etheridge? Miss Etheridge?
Yes, sir.
Counsel, what is your name again, sir?
Tim Flaherty.
Mr. Flaherty's going to represent the defendant. He says you're representing him right now.
Yes, Your Honor. We had received his notice of appearance, and I guess he had asked for the PD to be received.
All right, I'll allow the public defender to withdraw. And Mr. Flaherty, you've entered a notice of appearance already?
Your Honor, normally we would wait for the court to grant the motion to relieve, but we'll file our notice of appearance today. We'll also enter a denial to the violation, and we'll request a court date on that violation.
All right, I've got December 29th and January the 5th.
We'll take, if the court would allow, the January 5th.
Any objection from the state?
No, Your Honor, will that be with or without subpoenas?
Without at this point.
January the 5th, no subpoenas, 9 a.m.
Thank you, Your Honor. That's all I have.
Okay, thank you, sir. Rocky Carter. Rocky Wayne Carter.
Isn't.
Is he incarcerated?
Yeah, yes, Your Honor.
Okay.
Casey Etheridge for Rocky Carter. And Your Honor, we would be entering a denial on the VOP for today, and we'd ask to set this with his, tracking with his new law violation, which is set for December 28th.
Any objection from the state?
No, Your Honor.
All right, we'll pass this to December the 28th at 9 a.m.
Thank you, Your
Mhm.
Honor.
Chelsea DiCarlo. Are you Chelsea DiCarlo?
Casey Etheridge for Chelsea DiCarlo, Your Honor. And Your Honor, so Ms. DiCarlo is here because she still owes some outstanding restitution. And the state's made her an offer to extend her probation. She does have some issues, which I hadn't had a chance to discuss with the state yet. We were asking if the state would be willing to just let her reduce the lien. The state saying no. Okay. Would you like to accept? Okay.
It looks like the allegations of violation of failure to pay restitution and failure to pay court cost.
Yes, Your Honor. There's substantial restitution, I believe. I don't remember the amount. I know that she's paid, I believe it's several $1,000s, Your Honor.
Okay, according to the affidavit, she's $9,456.65 in arrears.
Right. And she's also, but she's paid like, I think $5,000 or something like that, $5,000 or $6,000. So that's what. So, but she would like to admit to the allegations in the affidavit and accept the state's offer to revoke and terminate probation and sentence to a new term of 24 months of probation with her cost supervision will be waived, an additional $100 cost of prosecution, an additional $150 in public defender fees, and then she must pay the restitution at least $100 per month during the 24 months.
All right. Mr. Carl, would you raise your right hand and be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth? And you're Chelsea Renee DiCarlo, is that right? You can put your hand down, ma'am. And ma'am, you're charged with violation of probation today for failure to pay court costs and also failure to pay restitution. And your attorneys indicate you're going to admit that violation today. Is that what you want to do? All right, the court's going to, she's got a written plea here. I'll accept the written plea. And at this time, I'll continue to withhold the adjudication of guilt. Her probation will be revoked. And place her on a new period of probation. That's what the agreement was, is that right? For a
Yes, Your
period
Honor.
of- For a period of 2 years, $150 defense, an additional, all the original terms and conditions of the probation will be reimposed on this probation, and in addition, she'll pay another $150 toward the public defender fee, $100 cost of prosecution, and a waiver cost of supervision, and she'll be required to pay no less than $100 per month toward the outstanding restitution obligation. Ma'am, you have a right to appeal, 30 days to appeal. If you can't afford an attorney, one will be appointed for you. Good luck. Jonathan Brody Johnson.
He's in custody, Your Honor. 1 minute. Casey Etheridge for Jonathan Johnson. May I have 1 moment, Your Honor? Your Honor, we would like to leave this set on the docket for pretrial conferences. I believe it would be December 28th, Your Honor.
Both cases?
Yes, Your Honor. And just for the state's knowledge, I believe Mr. Johnson would like to go to trial, so.
All right, so you want to leave it on the docket for December 28th at 9 a.m.?
Yes.
All right, that's a pretrial conference.
Yes, Your Honor.
Has it already been set for trial?
No, not specifically. I mean, it would be set on that date.
On pretrial
so,
date?
Yeah.
Okay, all right. So they'll bring you back on those dates. David Russell?
No, he's a dig, I'll get you. Good morning, Your Honor. Tim Gibbs on behalf of Mr. David Russell, 21 CF 2535. We were originally set for a bond hearing this morning, Judge. However, we have reached an agreement with the state. Mr. Russell is going to withdraw his previously entered not guilty plea and enter a plea of no contest. The agreement with the state on these charges, for count 1, he'd be placed on 36 months of probation with adjudication withheld, ordered to pay $100 cost of prosecution, $767 in court costs, $150 public defender fee, have no violent contact with HAR, a juvenile, undergo an anger management course, also undergo a mental health evaluation with any recommended follow-up treatment. I believe he's going to be seeking his own counselor. That should cover both of those. The state is recommending family counseling. That's not necessarily a requirement, but it is being recommended. Count 2, the resisting charge will be time served, if I can approach with a written plea.
Yes, sir. All right. All right, sir, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
I do.
What is your name, sir?
David Malik Israel Russell.
All right, sir, you put your hand down. Mr. Russell, I have a written plea agreement. It's dated December the 7th. That's yesterday. Has what purports to be your signature. Is that your signature, sir?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you go over it with your attorney?
Yes, sir.
Did he satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning?
No, sir.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense of the charge with your attorney? And are you satisfied with the services of your attorney?
Yes, sir.
Has anybody forced, coerced, or threatened you to sign this written plea?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
So what you tell me is you're entering this plea freely and voluntarily of your own will. Is that right?
Yes, sir.
Is he related to the victim in this?
Yes, Your Honor.
And what's the relationship?
I don't know if it's biological father, but
Biological, he is her biological.
Biological father of the child? How old is the victim?
14.
She's now 14, Your Honor.
This has been, you run this by the victim and her mother?
Yes, Your Honor. It was discussed previously.
All right, the court's going to find then that on count one, first of all, I'll find the plea freely and voluntarily entered. On count one, that's the aggravated assault with a deadly weapon. I'm going to withhold the adjudication of guilt at this time, place him on probation for a period of 36 months with the following special terms and conditions. He'll be required to pay $100 cost of prosecution, $767 court cost, $150 public defender fee. He's not to have any violent contact in any way whatsoever with the minor child. Initials H.A.R., date of birth October 8th, 2008. He'll be required to undergo anger management counseling. He'll also be required to undergo a mental health evaluation and follow through with any recommended treatment. This is an appropriate case for family counseling, so I'm going to require that as well as part of his probation. Sir, you have a right to, and on count two, the resisting an officer, he'll be sentenced to time served, and I'll go ahead and withhold adjudication on that one as well, since that's
Thank you, Your
what
Honor.
the agreement says. Sir, you have a right to appeal the legality sentence of the court. If you can't afford an attorney, one will be appointed. You have 30 days from today to file your notice of appeal, and you will need to be fingerprinted on this charge.
And, Your Honor, based on the defendant being found indigent, we request a supervision be waived.
All right, cause supervision will be waived.
Thank you, Mr. Berry.
Elena Sandstrom.
Good luck.
Urgent.
Your Honor, Tim Gibbs on behalf of Alana Lee Sandstrom, 20 CF 2298. Your Honor, Ms. Sandstrom, I believe, is here for her VOP arraignment. We have reached an agreement with the state on this case. She's going to enter an admission to this violation of probation. The terms of that sentence would be that her probation would be revoked and terminated. She'd serve 6 months in the county jail with credit for time served, $100 cost of prosecution assessed, $150 public defender fee assessed. That would be due within 180 days of release. There is also a $101.83 cost of transportation to the sheriff's office. I may approach with a written plan and score sheet.
And that's the state's agreement.
All right, ma'am, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And what is your name?
Alana Lee Sandstrom.
Okay, Ms. Sandstrom, I have a written plea agreement dated today, has what purports to be your signature. Here it is. Is that your signature, ma'am?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
I did. May I please speak, Your Honor?
Pardon me?
Can I speak?
Yes, ma'am.
I was just wondering, with the time served, is that also including the 60 days that I did in Walton County with a hold for Okaloosa County?
So a hold is not necessarily going to give you credit. All you were waiting on in Walton County was to come.
Were you being held in Walton County on a charge for which you were arrested over there or over here, and it just took them 60 days to transport you?
I was being held for a charge that was a violation of probation over there with a violation of a hold for over here, too.
Normally, you would not get credit for that in this county.
Okay.
You understand that?
Yes, sir.
You still want to go forward with your plea?
Yes.
All right. All right, the court's going to find the written plea is freely and voluntarily entered after she's had the benefit of advice of counsel. The court will accept the plea. She'll be adjudicated guilty of the violation of probation, and if she hasn't already been adjudicated, she'll be adjudicated guilty of the underlying offense. The court will revoke the probation, revoke and terminate. She'll be sentenced to 6 months in the county jail. She'll get credit for all time served. On this charge, she'll be required to pay $100 cost of prosecution, $150 public defender fee, due within 180 days from the date of her release, failing in which it'll be reduced to or be sent to collections. And Cost of supervision to the Okaloosa County Sheriff's Department will also be awarded in the amount of $101.33.
83 cents, Your Honor.
How much?
83 cents.
83 cents.
The handwriting is not the best.
Okay, $101.83.
Thank you, Your Honor.
Ma'am, you have a right to appeal the legality sense of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days.
Thank you.
Thank you, Your Honor.
James Thomas, Jr. There's two Thomases. We're looking for James.
Your Honor, Tim Gibbs on behalf of James Thomas Jr., 19 CF 1448, 21 CF 1143. Your Honor, at this time, we're going to request to continue this to January 5th. We're waiting on an evaluation for Keaton to potentially have him go to treatment there.
No objection, Your Honor. We could set this for 9 a.m. without subpoenas on the 5th.
Perfect.
All right, we'll pass this until January the 5th at 9 a.m. And did you say with or without subpoenas?
Without subpoenas.
Without subpoenas. January 5th, 9 a.m.
Thank you, Your Honor.
Then we have Javalis Thomas.
We're just waiting them for that of it. Your Honor, Tim Gibbs on behalf of Jarvelis Thomas, 19 CF 2582, 19 CF 2598, 19 CF 2663. We're also looking into treatment options as well as negotiations with the state. I believe Mr. Thomas does want to address the court about his case this morning. My advice would be not to speak about the facts of his case, and otherwise that he may not necessarily need to talk. I don't know if Your Honor would like to hear from Mr. Thomas this morning regarding his case or whatever he might like to say. Do you still want to speak? We could pass him this for now this morning, Your Honor, and bring him back later on in this morning's.
All right, we call the case.
Thank you, Your Honor. Yes, hold on. Yeah. No, not right now.
Jenny Lynn Turner.
Your Honor, Tim Gibbs on behalf of Jenny Turner, 20 CF 374. Your Honor, this morning she'd like to enter a denial, and if we could set this for January 5th without subpoenas. There's been several options on the table as far as how to resolve this, so we're going to be looking into those a little further, try to get it resolved by that date.
No objection.
All right, without objection, we'll pass it to January the 5th at 9 a.m. without subpoenas.
Thank you, Your Honor.
Ronald Way. This is here for a bond hearing.
Your Honor, Tim Gibbs for Mr. Way in 21 CF 16, 21 CF 2965. He is scheduled for a bond hearing this morning, Your Honor. However, I believe we have a resolution. If I may have just one moment with Mr. Way.
How are y'all doing? Y'all need a break? Sure.
Your Honor, he's signing his written plea at the moment. Terms of this plea, Your Honor, on these 2 violation of probation cases, he does have his 5-year suspended sentence. That's going to remain suspended. His probation is going to be reinstated. He was originally placed earlier this year on 3 years of probation. That's going to be extended by 2 years of probation for a total of 5 years of probation. While he is on probation, he needs to go back and complete REAP in Pensacola. I believe that they will accept him, as well as he has a place to live over there. Following his completion with REAP, Your Honor, he is to go to a VA program. He has a point of contact named Mark Ballou, with whom he has been speaking to get that treatment set up. There was a GPS monitor that's going to be required due to the Jessica Lunsford Act. We're asking it no more than $1 per day, but otherwise waiving the cost of supervision in this case due to the fact that he has been found indigent.
Yeah, that is the state's agreement. Ready, sir?
If I may approach, Your Honor.
No objection to the score sheet. All right. All right, sir, would you raise your right hand to be sworn? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And what is your name?
Ronald Way.
Mr. Way, your attorney just handed me a written plea agreement. It has, it's dated today, has what purports to be your signature. Is that your signature, sir?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you go over with your attorney?
Sir.
Did he satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning?
No, sir.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney, Mr. Gibbs?
Yes, sir.
Has anybody forced, coerced, or threatened you to sign this written plea agreement?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
So what you tell me is you're entering this plea freely and voluntarily of your own will.
Yes, sir.
All right, the court's going to find then that the, and has he pleading to the VOP?
He's admitting the violation.
The court's finding that the admission to the violation of probation, both cases, 2116, 21 CF 16 and 21 CF 2965, is freely, voluntarily, and intelligently entered after the defendants had the benefit of advice of counsel. The court will accept the plea. He'll be adjudicated guilty of that violation of probation on both cases. It's going to be the judgment sense of the court that his probation be reinstated to the original terms and condition, and in addition thereto will be modified to extend the probation by an additional 2 years for a total of 5 years probation concurrent with these cases and counts. The court previously imposed a 5-year state prison sentence. The court is going to reimpose that. However, that will remain suspended, conditioned upon the successful completion of these probations. He'll be required to enter and successfully complete the REAP program, then follow that by treatment with the VA Veterans Center, and the contact person there will be Mark Ballou. He'll be required to wear a GPS monitor per the Jessica Lunsford Act, and the court will assess the cost of that at no more than $1 per day. I'm going to waive the cost of supervision on this case.
Thank you, Your Honor.
Sir, you have a right to appeal. The legality is sense of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. You will need to be fingerprinted on this, and this is a downward departure. The court's finding the reason for the departure has been a agreed upon plea agreement.
Thank you, Your Honor. So you'll need to be fingerprinted.
Your Honor, the defendant asked the court to remain in custody until his GPS is hooked up. That's number one. And number two, is the court inclined to remand him to custody until REAP picks him up?
He has a camper that he is going.
Will they come over and transport him from the jail?
They won't pull my camper.
He has a
Don't pull that raggedy camper.
he's got it, and that's how he's staying over. on their property.
And the camper be pulled. We still request that he remain in custody until such time the GPS.
And what, I heard part of what you said about Tampa. I didn't hear everything. You were talking among yourselves.
He has a camper, Your Honor, that he's going to be staying in, that he owns while he is at REAP. I believe Mr. Berry was requesting that he remain in custody until REAP come get him. Because he has a camper that he is going to tow himself to REAP's property in Pensacola, we're asking that he be allowed to be released once the GPS monitor is placed on him, because he was able to transport the camper himself.
Well, he'll be staying, when REAP picks him up, he'll be staying at the REAP facility, will he not?
He will be staying on their property, Your Honor. I've spoken with another contact that's spoken with REAP. They will allow him to stay on their property within a camper that he owns. There's a few other folks that are also doing that currently through the REAP program. They will allow him to stay on their property with his own camper. He's able to tow that himself. He has a vehicle. Well, I don't have an objection to him remaining in custody to put the GPS monitor on him.
Let's do this. I'll go ahead and order that he remain in custody until the GPS is in place, and that he'll be required to report to REAP in the camper within no more, let's see, shouldn't take him more than a couple hours to get over there, I wouldn't think.
Right. Roughly.
More than 3 hours?
Yeah. I'll give him 4 hours from the time he's released from the county jail. After he gets a monitor, he'll have 4 hours to get over to REAP and check in with them and get his camper set up. Failing in which, I would expect a VOP warrant again.
Thank you, Your Honor.
So you have a right to appeal, 30 days to appeal. If you can't afford an attorney, one will be appointed for you.
Still coming.
Elijah Westbrooks.
Your Honor, Mr. Westbrooks is present approaching. Tim Gibbs on behalf of Elijah Westbrooks, 22 CF 2012. This is a violation of probation, Judge. He's going to enter a denial this morning. He also has 22 CF 2738 that I believe is already on the pretrial docket for December 27th. So we'd like to track this case with that new law violation.
Any objection?
No objection.
All right, we'll put the VOP on for December 27th at 9 a.m. along with the new law violation.
Thank you, Your
We'll
Honor.
be back in court those dates and times.
Is it?
Yeah, thank you.
Michael Glenn Wise.
Your Honor, Tim Gibbs on behalf of Michael Wise, 22 CF 1841. This has been set this morning for a status call. I believe we have reached an agreement with the state, Your Honor, if I may go over that briefly with him. To you, that's where you need to send it.
No problem.
Probably contact.
Yes.
Your Honor, in this case, Mr. Wise is charged with, go ahead and date it, with tampering with an electronic monitoring device. He's entering a plea of no contest, withdrawing his previously entered not guilty plea. With that, Judge, he's going to be adjudicated guilty, be sentenced to 7 months in the Okaloosa County Jail with credit for time served, be assessed a $100 cost of prosecution, $415 in court costs, $150 public defender fee. There is a $1,000 in restitution. I believe that ultimately goes to state probation. I have written on the written plea agreement as well as handed him a copy of a P.O. box to where he needs to send to remit that payment. All of that money, Judge, would be due within 180 days from his release. Otherwise, after that, it would be reduced judgment. If I may approach with a written plea and a score sheet.
Sir, would you raise your right hand to be sworn, please? Do you swear affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
What is your name, sir?
Michael Glenn Wise.
You can put your hand down, Mr. Wise. Mr. Wise, I have a written plea agreement. It's dated today, has what purports to be your signature. Is that your signature?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
Yes, sir. It is credit for all time served, right?
Yes, you're getting credit for all the time that you, whatever the jail calculates.
And are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney?
Yes, sir.
And are you satisfied with the services of Mr. Gibbs, your attorney?
Yes, I'm going to thank the state for her grace, too.
Has anybody forced, coerced, or threatened you to sign this written plea?
Sure.
Have you had any drugs or alcohol within the last 24 hours?
Sure.
So what you tell me is you're rendering the plea freely and voluntarily of your own will, is that right?
That's correct, sir.
This is a new law violation.
It is, Your Honor.
What, was he on probation and he had a monitor on?
He was on probation out of Georgia through the Interstate Compact, being supervised here in Florida. There was back in 2001, I believe he had been qualifying offense that put him on a GPS monitor. That was why it was on him at the time.
What's the status of the Georgia case then?
He's still on probation. I don't know if Georgia is going to come get him or if they're going to violate him. Don't believe they will. He's otherwise not scheduled to terminate that probation until sometime in 2027.
Your Honor, if I may, a violation report was sent to Georgia?
Georgia,
The state
yes.
of Georgia for him committing a new offense. Georgia's position and Interstate Compact's position is to see what happens on the new charge, and then they will act accordingly from Georgia. Since he's pled here, we will advise Georgia, hey, he's pled to the new charge in the state of Florida, and then Georgia will give us marching orders on what to tell him to do, whether it's they're going to come get him and he have to return to Georgia, or they reinstate him, or whatever they choose to do.
But the electronic monitor that he was having was a result of the Georgia.
It was a result of a Florida case from 2001. He has, since, of course, moved a few times. There was an L&L conduct charge from 2001 that required the Jessica Lunsford Act to.
That's what I was trying to figure out.
I was released.
We got a violation of a tampering.
He was being supervised here in Florida, out of Georgia, and probation recognized that the Jessica Lunsford Act may have required that he be on a GPS monitor.
All right, the court's going to accept the plea then of no contender, finding it to be freely, voluntarily, intelligently entered. After he's had the benefit of advice of counsel, he'll be adjudicated guilty on it and sentenced to 7 months in the county jail. He'll get credit for time served. $100 cost of prosecution will be assessed. $150 public defender fee also will be assessed, as well as $415 in court cost. The defendant will also be required to make restitution in the amount of $1,000 to the state, and that'll be paid to the state accounting office at P.O. Box 12,300, Tallahassee, Florida 32317. Sir, you have a right to appeal, and he'll have 180 days to pay these court costs, failing in which he'll be reduced to a judgment lien that'll accrue interest at the legal rate for which let execution issue, and that can be referred to collections as well. Sir, you have a right to appeal the legality sense of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal.
Thank you, Your Honor.
Thanks, sir.
You will need to be fingerprint on these as well.
Ability to see him. Your Honor, I do have a gentleman on this afternoon's docket that is here this morning, Mr. Eric Russell. He's here. He's number 11 on my docket for the afternoon. He has arrived this morning, so if we could address his case.
Eric Dwayne Russell?
Yes, sir.
Okay, he's got 2 cases, is that right?
Yes, Your Honor, 22 CF 718, 22 CF 719. He has arraignment this afternoon. He'd like to plead not guilty to these charges. If we could leave this set for pretrial 12/20.
No objection.
All right. Court will accept his plea of not guilty and set it for pretrial conference on December 27th at 9 a.m.
Thank you, Your Honor.
Your Honor, briefly, Mr. Way, who had the camper, he just advised us that the camper, and I can advise the court, there's no telling what condition this camper's in, is in Ponce de Leon, Florida. So you gave 4 hours to get the camper and himself to read. I'm just letting the court know that he's giving us additional information about the location of the camper.
We don't,
We still have 4 hours, is that still good?
Honor, he says he's confident that he can make that time.
4 hours to get over to Ponce de Leon? What condition, sir, stand up a minute. What condition is the camper in?
It's in fine, it's a 2011, it's fine condition, sir. It's in good condition, it'll pull everything, there's no problem with it. All I gotta do is get over there, hook up, and leave, that's it. Literally take me 10 minutes to hook up and be out of there, on my way to Pensacola from there. It's on this, it's closer to us than it is actually they just give it a Ponce de Leon address where it's at. So, I can make it.
Where is that, Holmes County or Washington County?
It's right in Walton. It's right outside of Puniac Springs.
It would be on the Walton County, Holmes County line, basically. Be the other side of Holmes County, how's that? I mean, the other side of Walton County.
Just outside of Walton.
It'll take him probably 45 minutes to get to Walton County.
Yes, sir.
Pick up and get back 3. Let's give him 5 hours.
Okay, thank you, Your Honor. I just wanted the court to be aware.
Thank you, Mr. Berry. 5 hours. Make sure they don't still don't.
Richard Nunes?
Russell Public Defender's Office. Mr. Attorney Brad Stewart is here, so if you want to call these cases, that's fine with us, Judge.
Thank you, Councilman.
What about the attorney over here? Who are you waiting on?
We're waiting for Ms. Sherlock to show up for sentencing.
You still? You haven't been able to get in touch with him? He knew he was supposed to be here at 9 o'clock? Have you been having contact with him, or when?
We could go today to DOC time, and the state generously agreed to an ROR bond for her to take care of her to DOC. Advised by me multiple times, advised by the judge to be here. I don't know why she's not here. Hospital or.
And was scheduled for sentencing?
Yes, Your Honor.
All right. Well, let the record reflect Crystal Denise Sherlock has failed to appear for sentencing. Her attorney is present. The attorney from Attorney General's office is also here. She's failed to appear. I'm going to issue a capias for her arrest, failure to appear, no bond. All right. Now we've got Mr. Sherlock's cases. Is that right?
Good morning, Your Honor. May it please the Court, Your Honor, Brad Stewart, present. My first client, non-custody client, is Mr. Jordan Harris, Judge. This is 22 CF 2431. Mr. Harris is present before the Court, Judge, and I believe we do have a stipulation as it relates. We're before the Court with regards to our request to modify pretrial release conditions. We are going to clean up some language in the order. I anticipate providing that order to the Court in either later this morning's docket or this afternoon's docket. I'll appear before the Court. If, for whatever reason, Your Honor, mechanically we cannot do that, is there a mechanism by which we standard file before the portal? As we want to try to get this order in place so that my client can have contact with his minor.
Under what conditions?
Is the Court requesting the conditions of the modification?
You're right.
Yes. The conditions that we've agreed upon are contact with the minor child at FFN or DCF approved location with DCF workers that he may attend, of course, the follow-up doctor's appointments. There was also a request excuse me, for travel purposes. We have included some language in there that would allow him to travel for work purposes, TDY, brief deployment, things of that.
Other states understanding?
Yes, Your Honor, as long as the DCF or FFN workers were physically present in the room during the supervised
It would have
contact.
to be supervised visitation by the department or one of their representatives.
That's correct, Your Honor.
All right. If you can't get the, as you put, the mechanics of it worked out, you can enter into a written stipulation and then have the JA put it in my my electronic folder for
Very good.
electronic signature.
Very good. Thank you, Your Honor.
Okay.
No,
But that would have to be a written stipulation if you can't get it resolved by this afternoon.
Very good.
All right.
Your Honor, I have two other clients on the court's docket that are incarcerated. My first client is Mr. Kenneth Fuqua. And for the record, Your Honor, Brad Stewart, on behalf of Mr. Fuqua, case numbers 18 CF 512 and 522. Mr. Fuqua is present before the court, Your Honor. If I may pause for a moment to verify the previously signed written plea agreement. She just signed it. Right. I didn't have that. So it's total. 5 total. Your Honor, may I approach? Yes, sir. Your Honor, this time, Mr. Fuqua, violation of probation, with the understanding that there's going to be a modification. He's going to be reinstated for 6 months of community control. There will be an additional requirement for anger management course to be had. I believe, I don't know if I included in there, of course, there will be a VOP fee.
Just if I could interject, it was supposed to be 6 months, the first 6 months, community control.
6 months.
Yeah. just-
Reinstating complete original requirements, 6 months, first 6 months.
All right, sir. Mr. Fuqua, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes.
And what's your full name?
Kenneth Thomas Fuqua.
Mr. Fuqua, I have a written plea agreement. It's dated yesterday, the 7th, has what purports to be your signature. Is that your signature?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you go over it with your attorney?
Sir.
Did he satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning?
Sir.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney?
Yes, sir.
Are you satisfied with the services of Mr. Sherlock, your attorney?
Sir.
Has anybody forced, coerced, or threatened you to sign this written plea agreement?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
Sir.
So what you tell me is you're entering this plea freely and voluntarily of your own will. Is that correct?
Sir.
All right. The court's finding that the written admission to case number 2018-521 and 2018 CF-522 is freely, voluntarily, and intelligibly entered. All counts. After the defendant's had the benefit of advice of counsel, the court will accept the plea. He'll be adjudicated guilty of the violation of probation. And
It was a modification to reinstate.
pardon me?
It was a modification.
Right. And the court's going to reinstate the probation that he was originally on. All the initial terms and conditions of that probation will be reinstated on this probation. And in addition thereto, he'll be sentenced to 6 months community control, and that'll be the first 6 months starting today or from when he's released from county jail. under all the community control sanctions. In addition thereto, he'll be required to attend and successfully complete an anger control management course. The court will waive the cost of supervision if it hadn't already been previously waived. Sir, you have the right to appeal, and that's on both cases, all counts. You have a right to appeal the judgment sent to the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. This is a guideline sentence, and you will need to be fingerprinted on those charges.
Thank you, Your Honor. Your Honor, my next client is Mr. John Russell Harvard. Mr. Harvard is incarcerated, and for the record, this is case number 22 CF 1810. If I may pause while Mr. Harvard approaches.
I've got this docketed for a bond hearing, is that right?
That is correct, Your Honor. And for the record, Brad Stewart, on behalf of Mr. John Russell Harvard, 22 CF 1810, Mr. Harvard is present. We are before the court with regards to counsel's, Mr. Harvard's motion to reduce bond, Judge. Mr. Harvard was arrested from a posture standpoint on July 15, 2022, charged with a 5-count information of aggravated assault with a firearm without intent, open carry of a firearm, display of a weapon, possession of a firearm by a convicted felon, and misdemeanor battery. Judge, the bonds were set at $570,000 cash professional, which is tantamount to having no bond at all. I would, from a factual standpoint, Judge, point out that the date of event was July 15, 2022. The probable cause narrative indicates that the time of the event was approximately 1900 hours or 8 o'clock. And he was arrested at or around that time, according to the arrest report. However, no firearm was recovered. I want to point out, Judge, most compelling, that Mr. Harvard has been diagnosed with end-stage liver cancer. That was verified by pretrial services. Specifically, Judge, clerked in entry number 16. The pretrial mental health report indicates that they verified that through hospice. Has been provided a diagnosis and approximately 6 months to live based on the advanced nature of that. As it relates to pretrial's analysis, he scores 4 total points with regards to the pretrial risk assessment, which is category low. We want to point out only those 4 points are because he was unemployed. Given his health circumstances, certainly seems reasonable that he would be unemployed. As far as significant factors for bond, Judge, he is a he does come from a pioneering family here in North Okaloosa County. They own real property here. He has significant ties to the community. He has his own home. It does not appear as though he is getting treatment in the Okaloosa County Jail at this point. However, I'm not entirely sure that the county jail is aware in totality of all of the circumstances of his physical condition, Judge. It does appear as though there is some felony criminal history. I want to point out that the last substantive case was in 2013. There is one FTA in 2014 as well. He's been incarcerated since the date of arrest, Judge. Again, a bond amount of $570,000 is tantamount to no bond at all. Mr. Harvard is requesting the court provide him with a signature bond and allow him to enter into mental health pretrial services. Again, he was approved for that, and that was a recommendation by pretrial. That will afford him an opportunity to receive the medical treatment that he certainly needs. And obviously, Judge, there are other mechanisms by which we can ensure, if the court is so inclined, for a GPS monitor, things of that nature, in addition to being monitored by...
Yes, Your Honor. This matter was previously addressed at his prior bond hearing on October 6, 2022. Judge Ketchel found him to be a danger to the community. His unfortunate predicament we are all aware of it, and we do have sympathy for him for that. If you notice the confidential mental health report, Mr. Harvard has refused any medical treatment. He was asked to leave hospice because he discontinued all services. He did not want treatment. He obtained his loaded gun from, I believe it's his significant other, at the time that this event occurred, so he knew of his end-stage diagnosis at the time that he committed this crime, and he went and did it anyways. There's nothing that can prevent him, absent being put in a secured facility of some sort, nothing to prevent him from going out and getting his significant other's gun again, or getting a knife and threatening harm or inflicting harm on the public again. And Judge Ketchel found him to be a danger to the community, and the state agrees. Unfortunately, there's nothing to protect the community at this point. And if he desires to resume treatment, because he had discontinued treatment, the jail has the capability to take him to his appointments.
Your Honor, if I may. Judge, as it relates to the prior bond hearing in October, that was prior to counsel coming on. Point that out. So I didn't want the court to think that there was multiple motions filed by same counsel. As it relates to the refusal of treatment, Judge, I do want to point out that in accordance with speaking with my client, as well as his significant other, it was a treatment choice by Mr. Harvard that he made. There was also a change of medication at or around the time of this specific event that substantially contributed to, from our perspective, what occurred. We believe that being on mental health pretrial services is going to adequately assist him in that regard, so that he can move forward with the best quality of life possible, given the circumstances. As it relates to the firearms, law enforcement has already been to Mr. Harvard's house, retrieved any and all firearms by his significant other that were at the house. I have no idea what they were. There's an injunction also that is part and parcel of this as it relates to victims as well, Judge. So that's safety and security mechanism also in place. As it relates to the jail providing treatment, almost a sentence to the taxpayers, quite frankly, given the significant nature of medical circumstance. We would request that the court afford Mr. Harvard some type of sanctity in his final days, what it appears.
Well, I'm certainly sympathetic with his physical condition, but I've read the probable cause statement, and it was aggravated, and I concur with Judge Ketchel's finding that he is a risk to the community, especially not having the mental health treatment that is necessary. So the motion to modify the bond is going to be denied.
Yes, Your Honor.
See you this afternoon.
Your Honor, I have one other matter that actually isn't on the docket, but it is a stipulated order that the state and I have agreed upon. If the court is inclined, if I may approach for the court. Yes, sir.
Thank you. You're going to have to give me a little more than this.
request and motion filed as it relates to Mr. Collingwood's case, that he be allowed to travel for work purposes. Mr. Collingwood owns a crane company and many times is required to travel to the state of Alabama, Louisiana, Arkansas, Georgia. He's on supervision with the department for a misdemeanor offense. In accordance with his employment, he's a small business owner. He owns his own operating system. So we're just trying to clean this up so that he can travel when he does have.
And who has agreed to this, Ms. Rivers or someone?
Yes, sir.
Yes, sir.
All right, I'll go ahead and approve this, subject to him advising probation before he goes out of town as to where he's going and when he's supposed to come back.
Certainly, the particulars of each travel.
Right. And
Because I did consult with probation, that would be a standard operating procedure for them, for him to provide the information, location, things of that nature. So we are all certainly on the same church, singing out the same.
okay.
Thank you, Your Honor. That's all I have before the court. May I be excused?
Yes, sir.
Thank you, Your Honor.
Your Honor, if I may recall Mr. Thomas, Jarvelis Thomas.
All right, Mr. Gibbs.
Your Honor, Tim Gibbs on behalf of Mr. Jarvelis Thomas, 19 CF 2582, 19 CF 2598, 19 CF 2663. Judge, after speaking with Mr. Thomas, we'd like to continue this matter to the 29th at 9 a.m.
No objection.
The 29th, with or without subpoenas?
Without subpoenas, Your Honor.
Without, and no objection?
No objection, Judge.
All right, Mr. Thomas, they'll bring you back on the December 29th at 9 o'clock, sir.
Thank you, Your Honor. That's all I have, I believe, this morning.
Next, Mr. Russell, next I have is Richard Nunes.
Charles Russell, Public Defender's Office. Judge, present approaching is Mr. Nunes. Case number is 22 CF 1355. This case was set for an early plea in exchange for a plea of no contest to the single charge of fleeing or attempting to elude. The agreed-upon sentence will be an adjudication of guilt, 42 months in the Department of Corrections with credit for any time served. Court costs, $100 cost prosecution, and public defender fee, all would be reduced to a judgment. And I have a signed plea agreement and a...
Sir, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Sir, I do.
What is your name?
Richard Nunes, Richard Allen Nunes.
You can put your hand down, sir.
Yes, sir.
And Mr. Nunes, I have a written plea agreement. It's dated November 29th has what purports to be your signature. Is that your signature, sir?
Yes, sir, it is.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
Yes, sir, I did.
Did you go over it with your attorney?
Yes, sir.
Did he satisfactorily explain the terms and conditions of the written plea to you?
Certainly did, sir.
Do you have any questions concerning it this morning?
No, sir, I do not.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney?
Yes, sir.
Are you satisfied with the services of Mr. Russell, your attorney?
Sir, I am.
Has anybody forced, coerced, or threatened you to sign this written plea?
No, sir, they have not.
Have you had any drugs or alcohol within the last 24 hours?
Sir, I have not.
So what you tell me is you're entering this plea freely and voluntarily of your own will, is that right?
Yes, sir, I am.
All right, the court's going to find that the plea of nolle contendere, case number 22 CF 1355, charging one count of fleeing or attempting to elude a law enforcement officer in an agency vehicle with siren and lights activated at high speed, is freely, voluntarily, intelligently entered. After the defendant's had the benefit of advice of counsel, the court will accept the plea. He'll be adjudicated guilty, and it's the judgment sense of the court that he be remanded to the custody of the Department of Corrections for a period of 42 months. He'll get credit for all time served. Court costs are going to be imposed. What are the court costs on this? Is it $415 or $548? $548 court costs, $100 cost of prosecution, $100 public defender fee, and all the financial obligations will be reduced to a judgment lien, and he's adjudicated guilty. You have a right to appeal the legality of the sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal, and you will need to be fingerprinted on this charge.
May I have one moment? Is there a state attorney here that I can ask a question real quick, if I may?
She's here. Whether or not she wants to answer it's another.
Ma'am, with all due respect, right, truly, what that you would need to know or would like to know?
You can write the Office of the State Attorney,
This district?
Rescue Office, if you have information you'd like to give.
All right. God bless you guys. Happy holidays.
Sumchai Whitman.
Charles Russell, Public Defender's Office. Judge, Mr. Whitman's not going to be with us. He's at the State Hospital. For the record, case number 17 CF 3017. On Mr. Whitman's case, Judge, he's at the State Hospital getting competency training. This date was set back in June by the judge as a status date, but we don't have a report from the State Hospital. What I propose to do today is set another control date, maybe 5 or 6 months out. If we get a report from the State Hospital before then, we can bring it in before then.
No objection.
I don't know, I've got dates that far out. Let's see.
Madam Clerk, do you have them? Why don't we do the 25th, and like I said, if we get something before then, we can set it.
All right, May 25th at 9 a.m. for review or status review, or until such sooner time as you said it.
Thank you.
Jody Yawn.
Charles Russell, Public Defender's Office. Mr. Yawn's case is in the same posture, Judge. He's not going to be here. He's at the State Hospital getting competency training. For the record, it's case number 21 CF 829. Again, we would ask to set it maybe to the May 25th court date, 9 a.m. for a control date. If we get a report from the State Hospital before then, we'll bring it back in before then.
No objection.
So ordered.
Thank you, Judge.
Cody Hinesley.
Judge, Mr. Hines. Bill.
Looks like he's got two cases, 22-1909 and 22-2449.
He's approaching now, Judge. There are actually 3 cases. He had a first appearance in case number 2022 CF 3039, and we received a copy of the notice to appear. What I'd like to do is just go ahead and arraign him on that. so that we can handle all three of his cases together. This is going to be a competency issue. We've got a report from the physician. I'm going to ask the state attorney in a moment if she stipulates to the admission of that report. And he's been determined to be incompetent, and we need to get him into competency training.
Does the clerk have the third file that Mr. Williams mentioned? You do? You have that? All right.
All right, so on that case, Jay Williams, with the Public Defender's Office, we have been appointed. I'll enter a plea of not guilty on his behalf, request trial by jury, and request 15 days to file any pre-arraignment motions. Now, Judge, we sent...
We'll go ahead and, when are the other two cases set?
They're currently on for the 28th.
Okay.
So I would suggest you set it on that date, although that may change in about 5 minutes.
Right. We'll set it on December 28th at 9 o'clock. And I'm looking for the, when was the doctor's report?
Judge, that was sent over to the state and filed not very long ago. I've got an extra copy of it I can provide to the court.
I don't see that it's been docketed yet.
Here, Judge, I'll give you my copy. It does have my highlighting on it.
State, get a copy?
Yes, Your Honor.
Okay. Thank you.
Relate to the admissibility of the report.
I do.
Are you seeking an independent examination?
No, I just have concerns about the recommendation, especially based on one of the crimes.
The recommendation, Judge, was outpatient treatment. There's no history of recent acts or threats of violence. I met with him at the jail and can confirm what the physician or what the psychologist observed in terms of his state of mind and his connection to reality. But essentially, the law is, in order to send him to the state hospital, you essentially have to, it's similar to the criteria for a Baker Act. There needs to be some recent act or threat of violence, something that shows that he represents a danger to himself and to others, and there simply hasn't been any evidence of that since he's in
Since he's been locked
jail?
up.
Yeah.
Yes. The concern is when he's released. We met with the victim just this week for depositions in 22 CF 1909. The state's concern is, based on Dr. Zeman's report, is that he is recommending outpatient restoration services based solely on the fact that he believes that Mr. Hinesley has family support, and that is the reason he is doing that. My understanding on the burglary of the occupied dwelling on 22 CF 1909 was that he broke in there and he stated he thought no one lived there anymore. He was looking for a place to live. So I haven't heard anything about any family members being here to help support him and make sure that he gets to his appointments, and so that's the concern I have.
Judge, the child that you've heard gurgling this morning is his nephew. His sister is present in court and prepared to provide further information.
All right, come on up, ma'am. Come on up.
We need to get you nearer. Come on up.
Sorry, I've been trying to keep it quiet.
Would you raise your right hand to be sworn? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Ma'am, would you please state your name for the record?
My name name is Lorena.
Ms. Hinesley, what is your relation to Cody Hinesley?
He's my brother.
Now, you described yourself a few minutes ago before you were placed under oath as his caretaker. Is that correct?
Yes, sir.
What is it that you do for him?
So I take care of that he's safe.
Has he been prescribed medication?
He has.
All right. And when these incidents occur, do they tend to be where he's gotten off his medication?
Yes, sir.
All right. With him involved in competency mental health training and them supervising the situation with his medication, do you feel like he's any danger to himself or to anybody else?
No. In the past, I guess it was a court order to be on his medication and to be here. So it's just the after that staying on medication. Once we find the right medication, that's the goal, because for him, and then he just doesn't like it. So finding the right medication for him is
Judge, back when I was a medic, our operations manager took Thorazine, and we referred to it as a Thorazine shuffle. It affected his gait, things along those lines. Judge, I was going to draft up the conditional release plan for you and was advised that actually the Agency for Persons with Disabilities drafts those up here in Okaloosa County, and then they will send, I guess, I know we get a copy. I thought maybe we get it and then we disseminate it. You guys may get it directly. I'm somewhat new to this much depth in Okaloosa County.
Ma'am, let me ask you this. Where is your brother living? Where was he living before he got arrested?
he was living at a friend's house.
Where do you live?
I live in Fort Walton.
That's a pretty good ways away. How do you supervise him?
Well, I go and check on him. Like, my whole family lives in custody. But, I mean, if he needs to stay with
You're going to need a plan. That's a good, I mean, how, you say you were supervising his medication. How are you doing that 40 or 50 miles away?
Well, he wasn't on medication. Before he was court ordered. Wasn't, that is when the problem, lied. So,
Is he on probation now, or does he have another case, or?
He has actually, at this point, Judge, a total of 3 new cases. One is
She said he was court ordered. In what case?
I thought you were talking about these cases.
this was a past instance. My mom told me. I just knew that.
Is that case still pending? It's not.
I'm not aware of any other, I'm not aware of him being on probation for anything, Your Honor.
Send me the plan and let me review the plan. I think that's the appropriate way to do it.
State concurs.
Because, going into someone's home, quite frankly, is dangerous to him as well as the homeowner. They think someone's breaking into his home, and
I don't understand.
they may take, measures that that may result in harm to your brother too. So we've got to make sure that whatever this plan is, he's going to be safe as well as the community.
Judge, I would concur, and unless other things develop, I'll probably be moving to dismiss the burglary, because there's no indication of what offense he was intending to commit while he was inside the residence. The only evidence is that he thought it was an abandoned residence, so what you would have is a trespass, not a burglary. All right, Judge, do you want to order APD, Agent for Persons with Disabilities, to do up a case plan and submit it to us prior to making will the court find him incompetent today?
Are you stipulating to this?
Yes, Your Honor, I do.
Yeah, based upon the report that Dr. Zeman or that you've allowed me to read from Dr. Zeman, I didn't see it docketed yet, but I have looked at it, and he's found him, or in his opinion, he's not competent to proceed. The court will find him not competent to proceed at this time and order, at this point, I'm going to order a plan to be put into effect, but then submit that to a court, and then either myself or whatever judge is sitting here can look at it.
All right, Judge, thank you very much. I'll note it as found incompetent, but the placement's under advisement.
Right. And in the interim, he'll be continuing the county.
All right. Thank you, Judge.
Let me return Dr. Zeman's report to you, Mr. Williams.
Yes, sir.
All right, Joshua King.
See you again. Try to expedite getting that release plan done, okay? All right. Judge, the next one I have is Joshua King. Mr. King is incarcerated. It may take a moment to get him out. Does the court mind if I call an arraignment case? This individual's... All right, I'll call him in a minute then, Judge.
This is Mr. King.
That's correct, Judge.
He's got a VOP.
That's correct, Judge. Hang on just 1 second. Judge, at this point, I don't think we have an offer on him. He's got about 30 days in, so we're going to deny the allegations, ask the court to reset us. Madam Prosecutor, do you think you'll be able to get an offer before the next?
Already has an offer.
Yes? All right, well, I'm missing it. What do you have?
So it's for 22 CF 1078. It is 9 months in the Okaloosa County Jail, plus reinstate probation for a period of 5 years because he's made no payments, and bed to bars would be the recommendation. Last time we were here, which was just a short time ago, we had offered him inpatient treatment because his crime is based on drugs, and he did not want to do that, and the state believes that that would help. But if he wants to ignore it again, then the state is still at 9 months Okaloosa County Jail, followed by 5 years probation and pay restitution within 120 days of release, and that he should make payments in the minimum amount of $200 per month. That would have it to where he could finish off making all restitution payments. If he were to pay it off early, the state would have no objection to him terminating early.
Judge, for now, we're going to keep the denial. I might suggest we put it on for another VOP arraignment date. Give him a little more time to think things over, give me a little more time to talk with the state and see if we can negotiate something a little more amenable to him.
December 29th or January the 5th?
I'm going to say January the 5th, Judge.
Rivers, good with you?
Yes, Your Honor.
We'll set it for January the 5th for a VOP hearing. Is that going to be with or without subpoenas?
I'm going to say without, Judge.
Without, okay.
Yes, sir.
William Manning.
Judge, Mr. Manning is likewise incarcerated. Hey, Mr. Manning. Judge, I just need to, I've gone over the offer previously with Mr. Manning. I saw him yesterday. He just needed me to figure out what his credit was. I've advised him of that, and he wants to accept the 90 days. Court will give me a moment. I'll get his signature on the agreement, or if you have another case you need to call, I can sit him down and do it. Prosecutor, I'm sorry. We don't have any objections to the...
All right, Mr. Manning, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth? And you're William A. Manning?
Yes, ma'am. Yes, sir.
Put your hand down, sir. And Mr. Manning, I have a written plea agreement dated today. It purports to have your signature. Is that your signature? And prior to signing this, did you read it? Did you understand it? Did you go over it with your attorney? Did he satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning? And are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney? And are you satisfied with the services, Mr. Williams, your attorney?
Yes, sir.
Has anybody forced, coerced, or threatened you to enter a plea this morning?
No, sir.
Have you had any drugs or alcohol within the last 24 hours? So what you're telling me is you're entering this plea freely and voluntarily of your own will. Is that right? It looks like this plea is in the alternative.
Judge, it's the 90-day county jail option.
Is that your understanding, sir? Is that what you want to do, take that option? All right, the court's going to find then the admission to the violation of probation, case number 21CF2180, possession of a controlled substance, is freely, voluntarily, intelligently entered after the defendant's had the benefit of advice of counsel. The court will accept the plea. He'll be adjudicated guilty of the violation of probation, and if he hasn't already, he'll be adjudicated guilty of the underlying offense. It's going to be a judgment sentence to the court. He'll be sentenced to 90 days in the county jail. His probation will be revoked and terminated. He'll get credit for time served. And the court's also going to impose $100 cost of prosecution, $150 public defender fees, and that'll be reduced. What, does he want 180 days to pay it, or does he just want to?
Let's give him 180 days and then to be reduced to lien if not
I'll give
paid.
him 180 days to pay the monetary amounts, failing in which it'll be reduced to judgment lien. That'll accrue interest at the legal rate for which let execution issue. And it can be sent to collections. Sir, you have a right to appeal the legality sentence to the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal.
Thank you very much, Your Honor.
That is a guideline sentence.
I don't estimate release dates, but take 90, subtract the 38, whatever it was I said, from it, and then figure out your gain time. Max is 5 days a month. All right.
That's everybody I had. Have I missed anyone?
Judge, I have, give me just a moment. I have a gentleman that's scheduled for this afternoon for arraignment. He came early. I'd like to go ahead and arraign him with the court's permission.
What's his name?
His name is Hutchinson, Judge. He is number 7 on this afternoon's docket, the 1:30 docket.
Charged with felony battery, case number 22-2758.
Judge, I checked earlier this morning. As of then, the clerk's computer was not showing that an information had been filed.
Let's see.
Filed an information on October 26, 2022. Damon?
No, this
Henrietta
is,
Hutchinson?
yeah, Damon Hutchinson.
Yes.
Yeah, I even had my secretary check on it. She couldn't find it for some reason. All right, so if the clerk's showing that an information has been filed, I'll enter a plea of not guilty, request trial by jury, and request 15 days to file any pre-arraignment motions.
Well, it looks like this was a transfer from where, county court?
Yes, sir.
I don't see an information docketed, but you say you filed it?
Your Honor, it wasn't me. It was Marshall Mull back October 26, 2022. Does the clerk's office not have an information? Okay. Yeah, that's it.
Okay, and what's the charge?
Felony battery.
Battery, you do have it? Okay, so you entered a plea of not guilty?
Yes, sir.
All right, I'll grant your request for pretrial motions. What'd you say, 15 days?
15 days, Judge.
Okay. And we'll set it for December 27th.
All right, Judge.
9 o'clock for pretrial conference.
Thank you. Ms. Rivers, if you... Thank you.
His name was Hutchinson. is that
Right, that was when it was in county court. It's been moved up to felony court, and so you don't have to... Judge, they've got on this as no release hold for judge. Since we've already arraigned him, he's shown up in court even though an information was filed on this direct file information where they transferred it up from county. Would the court give him an ROR or allow the original county bond to stand on it?
Can't do.
Okay.
I bonded out.
Right. That's because they moved it up the circuit. Again, I'll explain it all to you when you come in and meet with me. Some of these things take a few minutes to explain.
Oh, and he's made bond on the circuit cases. Okay.
Okay.
All right.
At this point, Judge, we don't even have a file on it. I'm working off of the court's docket. All right, Judge, and one last thing. I saw a guy at the jail last night named Marcus Ingram. Madam Clerk, let me give you a case number.
It's not set on the docket, Your Honor. We did look it up, and it is set for the 27th, I believe.
Okay.
It's the 27th or 28th.
All right, he was thinking
Yes,
it was
sir.
today for some reason, so I just wanted to be able to answer his question when I get a letter from him asking
He's an inmate?
me why he wasn't in court. Yes, sir, he's an inmate.
Okay, so it'll be December 28th then at 9 a.m.
All right, Judge, thank you. Okay, okay. Yeah, he asked me about it last night. I was seeing him about something else, just the routine, jail visits.
All right, well, that's all I had for the morning docket.
Your Honor, if I may recall one case, Your Honor.
Oh, yeah.
For the record, Brad Stewart, Judge, on behalf of Jordan Isaac Harris, Judge, 22 CF 2431. I did perfect the order modifying the bond conditions that we previously discussed. May I approach for the court's consideration? Reviewed and agreed to the verbiage included therein.
That's correct.
That's correct, you said?
That's correct, Your Honor.
Let me ask you a question. Not to muddy the waters, but is there also a dependency case?
There is, Your Honor.
Okay, in the dependency case, do you know if there's a no-contact provision?
There is not, Judge. There was a bit of the reason we filed the basis of this motion was to clear up everything for the dependency action, as there was a condition to follow and comply with DCF and FFN instructions, and there was also a no contact, as both of which were conditions of bond. However, he was, through the DCF case plan, having contact with the minor child until November 23rd, or I'm sorry, November 17th, which we filed the motion on the 18th. And we're trying to clear that up for both sides, and we believe this language clears everything up from both perspectives. Thank you, Your Honor.
All right.
That's all I have. May I be excused?
Yes, sir.
Thank you, Your Honor.
All right, thank you, folks. Appreciate your help, and we'll be in recess till 1:30 then.
Your Honor, I had one more thing
Oh, I'm
to
sorry.
bring up to the court. Oh, you're fine. So there's a Leanna Breyer. I filed a notice of hearing, but I don't believe that, it didn't come in time, and she did not get on the transport. I was just wondering if she could be transported at 1:30. She'd be entering a plea on this case, and it'd be resolved. I don't know if we can accommodate that or not, but, yes, it's 22 CF 2900.
What's her name again?
Leanna Breyer, I think it's how you say it.
Breyer, B-R-E-Y-E-R?
Brahier.
Any objection?
No, Your Honor, we have our file, we're ready.
I'm fine with her being on the docket if they can transport
Yeah,
her.
if they can transport her, if they can't, then it is what it is. Yeah, correct.
All right, with that, we'll be in
Thank you.
recess until 1:30.